'Cause you can't, you won't, and you don't stop. Or when you can't, you won't, and you don't stop.
Might be coming out for sure.
Now that we've looked at fiduciary duties, particularly as articulated in those 4 requirements under the Corporations Act, we're going to change pace and look at the second core duty of directors, that to act with due care and diligence. Now, this is a change of pace because those fiduciary duties were more about self-dealing and acting for the company, whereas due care and diligence is far more about paying attention and applying yourself to the role. So one thing to remember about due care and diligence is it evolved before we had the principle of negligence in common law, because there were directors around before negligence emerged. So it's kind of like negligence, and lawyers wouldn't like me saying that to some degree, but it is a bit like that, right? You've got to be applying yourself to the role if you're going to be a director. And so while it is technically a fiduciary duty, it's got a wholly different emphasis about it because of that historical development, which is why I think it's best to separate it out as a different kind of requirement of directors and officers. I think the other reason for separating it out is that it's the area of law that has developed most around directors and officers' duties, like outside of specific legislated requirements. This is the area where we've seen a lot of development. Society expects more of directors and officers. They expect them to apply themselves, to be responsible for what's happening. And while we've always had this expectation not to self-deal, that it's someone else's money and interests that you're dealing with, those fiduciary duties, right? This idea that you need to pay attention and apply yourself properly, the importance of that has increased over time and is probably only going to increase even more. So this is the area where there's a trend of increasing expectations from society. So let's get down to brass tacks and have a look at Section 180, which is the section that covers acting with due care and diligence. A director or officer, no employee, right? Notice that. Okay, so this is one that only the directors and officers. A directors or other officer of a corporation must exercise their powers and discharge their duties with a degree of care and diligence that a reasonable person would exercise if they were a director or officer in the corporation's circumstances and occupied the office held by and had the same responsibilities as that director and officer. So as we delve into this, what we start to see is this is an objective test, right? It requires directors and officers to act with what a reasonable person would. This is what makes it an objective test. It's not what the actual director or officer thought they should do. It's what a reasonable person would think they should do. Okay, so it's an objective test. But while it's an objective test, the standard varies. The standard is flexible. Why? What would a reasonable person think of a director and officer in the corporation's circumstances? So imagine you're a corporation for the local knitting group. Okay. Would you expect as much care and diligence of that group as, say, if you're a director of Google? Probably wouldn't require as much care and diligence in the knitting group, right? Reasonable person would expect that. So that's what we mean. What's going on in the corporation, not only kind of how big it is, but imagine that you're going broke, right? If you're in a company that's going broke, the company's circumstances, would you expect a director or officer to exercise more care and diligence? Yeah, you'd be worried all the time about what's going on, right? You'd be taking great care about what's going on. So what we expect will vary with the corporation's circumstances. It will also vary based upon the office held by the director. So think about this. Imagine you're a director who's also on the audit committee. Okay, so that's part of your office. You're also on the audit committee. Well, wouldn't you expect that person, wouldn't a reasonable person expect that director to pay more care and diligence with the finances? I think that there's a good argument that you would. So even within a board, in the same circumstances, the expectations of the individual may vary with their office. Okay, so very clearly, we have an objective test with a flexible standard. So while directors do have the same role in a company, they're part of the board, they face the same test, the same objective test. That means that test doesn't matter if they're an executive director who works full-time in the firm or a non-executive director who works part-time. However, having said that the test is the same, Section 180 is the same, however, the executive director has a different position. They work full-time, thus greater access to information, and we would often expect that they exercise greater care and diligence, right? So the standard, while the test is the same, the standard's going to vary. As a consequence, in most circumstances, the chair will also have a higher expectation because they hold greater responsibility, greater leadership role, and a pivotal role in communication. This is something that can be a bit hard to get your head around again, right? The test is the same. What would a reasonable person think? But the standard varies. What kind of company is it? What's going on in the company? What position does this director actually hold? What position does this person hold? Now, why is this occurring? Well, it's occurring because we're holding the individual accountable for a group-based decision-making process, right? And so we don't actually look at the decision. We don't care whether the board made a good or bad decision legally. That's not the test if a director has breached their duty. Whether the decision worked out is irrelevant. It's whether that director exhibited the behaviour required of them. What is that behaviour? Don't self-deal, fiduciary duty. Act with care and diligence, given what was going on in the company, what kind of decision you had, and your role in the company. Did you pay enough attention and apply yourself to that decision? And we do that for each individual because the law can only hold individuals to account, not the group. Okay? So that's why we get variation in the standard within the same test. So for historical reasons that I will go into. Historically, what actually happened? Okay. Most companies in their constitution used to write in that directors wouldn't be liable for negligence, right? So what did that mean? It meant that the Constitution, right, exempted directors essentially from this due care and diligence requirement. So if you were going to make a company and join it as a director, what would you do? You'd make sure that was in the Constitution before you joined. So virtually all companies had this exemption for directors for negligence. That meant in Australian law, very, very, very few directors early on ever got prosecuted or were ever subject to litigation around due care and diligence requirements. Then in 1989, when they changed the corporations law, they wrote into the corporations laws of the time that you couldn't put this provision in a constitution. You couldn't make directors, you couldn't indemnify them for negligence, right? So the government made a regulation that made it illegal for directors to be indemnified for negligence. So they couldn't put it in. And guess what happened? Suddenly, all these directors were getting litigation hit them about due care and diligence that had never happened before, right? Now, notice the law of due care and diligence hadn't changed. It was the ability to put an indemnity into the Constitution that had changed. Okay, why am I telling you this boring historical detail? As a result of that, the business community started saying, hang on, these requirements of due care and diligence, these are huge, right? And they're building. Look at all these people being sued, not realising why they were being sued, but saying their expectations are increasing. So the government was a bit worried about this, right? Because we want to make sure that companies can take risk. We've learnt that limiting the liability and taking risk is why the corporation has been a successful form and is behind much of the wealth that we have in society today. So the government really doesn't want to put an unnatural dampener on that. You just want to make sure that people are paying attention. So what they then implemented was a defence for due care and diligence called the business judgment rule. Okay. So the business judgment rule is a defence to the requirement for due care and diligence. What does that mean? It means if you can show you've met the requirements of the business judgment rule, you have fulfilled your due care and diligence requirements. Okay, so this is a total defence for due care and diligence for business judgments. So let's look at what you got to do to show that you have paid due care and diligence to the issue before you. So let's look at the actual business judgment rule, which is section 180, subsection 2, right? So back here, section 180, subsection 1, right? Due care and diligence. Subsection 2 provides us the defence. A director or other officer of a corporation who makes a business judgment, so it only applies to business judgment, is taken to meet the requirements of subsection 1, right? That's due care. So you've met your due care requirements and their equivalent duties at common law and in equity if they make the judgment in good faith for a proper purpose. Hey, hang on, that's our fiduciary duty. Oh, okay. So what they're saying is you can't breach your fiduciary duty and use this defence. Okay. Do not have a material personal interest, fiduciary duty. Okay, so notice here, if you are self-dealing, you can't use the business judgment rule. Okay? You have to be objective. You can't have a personal interest. You must be acting in good faith for a proper purpose. Okay, if you've done those things, then you have to inform yourself about the subject matter to the extent you reasonably believe. So you have to be informed about it, and there must be a rational belief. There must be a reason that the judgment is in the best interests of the corporation. The director or officer's belief that the judgment is in the best interest of the corporation is a rational one, unless the belief is one that no reasonable person would hold. Okay, so if it's a position a reasonable person would hold, it's rational, and if it's informed. If it's an informed, rational decision and you haven't self-dealt, you've executed your due care and diligence requirements. The real kicker, I think, in this is C. Have you informed yourself? Again, that's going to depend on the kind of decision, the company, what's going on at the time. Woo! So that's due care and diligence, the requirement to apply yourself. The critical element about applying yourself is keeping yourself informed and bringing an independent mind to those issues that are coming before you as a director. If you do those things and you don't self-deal, you're probably going to be okay under the basic requirements of directors and officers' duties. With that out of the way, we've covered the two main ones where the two main duties, fiduciary duties and due care and diligence. In the next video, we'll sum up the area by highlighting some of the other laws that may put duties upon a director and our ability to delegate given these requirements upon us.